Ali Taib, the Special Prosecutor, and Emily Kamau, the Deputy Director in charge of Economic Crimes. I have Mr. Owiti, who is a Senior Counsel, and Mr. Peter Muranga, who is also Senior Counsel. There's the media, in charge of media, Madam Beatrice. Good morning, everyone. Thank you for coming. It's a long statement, but please bear with me. Our Constitution articulates some of our national values and principles of governance to include integrity, transparency, accountability, equity, human dignity, inclusiveness, patriotism, and sustainable development, aspects that citizens expect everyone, especially those in positions of authority, to uphold. Upholding these values, which form the core of our soul as a nation, is vital to our very existence as a people. Whenever these values are betrayed by those in position of authority, who misuse their privilege to conspire, connive, and commit crimes against the people, our laws expressly mandate the law enforcement agencies and the Office of the Director of Public Prosecutions to set up and safeguard the public good and interest. Public corruption is a blatant abuse of power by persons in position of authority, and it threatens the very fabric of our nation. Kenyans have seen and experienced firsthand how public corruption tears us apart, undermines and destroys our governance structures, betrays the citizens' trust, and kills the civic spirit of people by robbing them of the hope that they can live in a country that is not fundamentally rigged against them, and which nobody is above the law, no matter how powerful. The Office of the Director of Public Prosecution draws its mandate directly from Kenyans, who enshrined it in the Constitution as a safeguard against crime and criminal elements. As the Director of Public Prosecution, I take my constitutional mandate seriously. Having seen the adverse effects of corruption in our society, the Office of the Director of Public Prosecutions has stepped up efforts to prosecute corruption and economic crimes and bring to account those culpable, no matter their station in life. I know that when citizens trust that our laws apply to all, and I mean everyone, then they will in turn uphold and respect the rule of law. The crime of corruption is not only against each of us individually, but also against all of us collectively as the people of Kenya. Each time we make the decision to charge and prosecute corruption cases, we know that we are safeguarding the public good. Each prosecution sends a powerful message to the corrupt, or those being tempted by opportunities to steal, that they shall be prosecuted. As a society guided by laws, we collectively agree that those corrupt individuals who put honest, hard-working Mwananchi at a disadvantage, at times even condemning them to loss of lives, must pay for their crimes. Most importantly, our message to every hard-working, law-abiding Kenyan, those who play by the rules and pay their taxes, is we are going to stand by you. On 18th September 2018, the Director of Criminal Investigations received complaints touching on governance and operation challenges in the management of the two dams, projects Aror and Kimorer, that required urgent attention. Upon investigations by the DCI, it was established that the conception, procurement, and payment process for the Aror and Kimorer dam projects in Elgeyo Marakwet County were riddled with massive illegalities. Having established this, the DCI and I set up a joint team that conducted further in-depth investigations which revealed that several persons and legal entities committed criminal acts and omissions. In late February 2019, I received a preliminary investigation report, and upon review, I directed on the 8th of March 2019 that the breaches of the law disclosed and their consequences were serious and merited a detailed and thorough investigations. I further directed that the joint team fast-track the investigations and engage international partners. In June 2019, the DCI submitted the investigation file to the ODPP for direction. The investigations established that government officials flouted all procurement rules and abused their oath of office to ensure the scheme went through. Many procurement procedures as stipulated by the law for such projects were ignored, and the law was circumvented to ensure that CMC de Ravenna got the contract. KVDA, Kerio Valley Development Authority, chose Public Procurement and Disposal Act 2005 for the concession agreements, despite the fact that the law in 2013 prescribed public-private partnership. The officials who should have pointed this out failed to do so and went ahead to award the contracts to CMC de Ravenna of Italy to run concurrently, while aware that the firm was at the time of award straining and getting into voluntary liquidation back in Italy. We also note that the same firm had been awarded 3 other mega dam projects that are either incomplete or are yet to commence. KVDA management failed to comply with the principle of value for money, which demands that there be competition among suppliers, efficiency and effectiveness in the procurement process, fairness and non-discrimination, integrity, transparency and accountability. This was in flagrant disregard to the laid down public procurement laws, regulations and rules, resulting in massive loss of public resources. Whereas the alleged commercial contract signed between KVDA and CMC de Ravenna, Itenera joint venture, clearly states that Kimorer Dam would cost US dollars 204,020,149.02, while Aror Dam would cost 252,188,732.27 million dollars, totaling to US dollars 456,208,881 million dollars, approximately Kenya shillings 46 billion. The National Treasury negotiated a commercial facility increasing the amount to approximately Kenya shillings 63 billion, which is 17 billion more than necessary or required, payable on a timely basis without regard to performance or works. We now also know that CMC de Ravenna submitted draft technical designs in February 2019, 4 years behind schedule. Further, the National Treasury entered into a facility contract in euros, while the commercial contracts were in US dollars, therefore occasioning further loss to the Kenyan government through exchange rates. Of note, out of the Kenya shilling 63 billion in respect of the projects, as at January 2019, the government of Kenya has made the following payments: advance payment, commitment fee, insurance and other costs totaling Kenya shillings 19,714,366,991. Out of this, Kenya shillings 11 billion for insurance was paid upfront. In contrast, if the borrowing was justified, a government guarantee would have sufficed at no cost to the government of Kenya and Mwananchi. Further, euros 40 million, approximately Kenya shillings 4.6 billion, was borrowed in addition to the principal amount to pay interest in advance during the construction period, which to date has not commenced. As a country, we continue to pay interest on the loan. I don't know if you've understood this point. We borrowed, the loan had interest, we borrowed more money to pay the interest, which also attracted interest. I hope that's clear. A further Kenya shillings 643 million was released by the National Treasury as counterpart funds, which was intended for the resettlement of the persons that would be affected by the said projects as compensation for the land acquired. However, there is no evidence that land has been acquired 4 years down the line. Furthermore, Kenya Forest Service, in a bid to protect our environment, strongly opposed any excision of forest land, pointing to significant adverse impact on the forest ecosystem. Based on expert opinion, if this project was carried out in strict adherence to the law and existing policies in place for safeguarding the public interest, it should not have cost Kenya shillings 63 billion. The evidence established malpractices that impacted on our public debt. A Treasury report dated 3rd March 2017 opined that, and I quote, if this borrowing is converted into Kenya shillings at the prevailing rate of 106.2, it translated to approximately a loan amount of shillings 61 billion. Added to the GOK total public debt stock of Kenya shillings 3 trillion as of 27th February 2017, debt stock increases of Kenya shillings 40 trillion, equivalent to 52.9% in the net present value of debt to GDP, which is above the limit of 50% provided for in Section 26(1) of the Public Finance Management Regulations. This advice was ignored. It is a high betrayal of public trust to disregard and breach public debt regulations. This kind of crime and irresponsibility enslaves us with unnecessary debt and mortgages our future generations. The persons we are charging today were mandated with safeguarding our public interest and deliberately breached this trust. Not only bound Kenya to a loan, but they ensured that the funds did not come into the consolidated fund, in effect guaranteeing that no one was oversighting its use. They broke the law on public finance management under the guise of carrying out legitimate commercial transactions. Colossal amounts were unjustifiably and illegally paid out through a well-choreographed scheme by government officers in collusion with private individuals and institutions. Upon receiving and reviewing the evidence, I am satisfied there is sufficient evidence to charge and prosecute the perpetrators. It is instructive to note that the national prosecution policy requires the evidential test to be met before the public interest can be considered. Therefore, in applying the evidential test, one must consider all the evidence and information available to the prosecutor. And in concluding that it is in the public interest to prosecute these cases, I have considered that such infractions are crimes against mwananchi, individually and collectively, and the decision to prosecute is in line with safeguarding the public good. This decision has been made professionally, independently, devoid of any external influence, political consideration, or any other extraneous matters. Consequently, I have today directed the DCI to effect the arrest and immediate arraignment before court of the accused persons named below hearing. 1. Henry Kiplagat ROTICH, Cabinet Secretary, National Treasury. Kamau Thuge, Principal Secretary, National Treasury. Dr. Susan Jemtai Koech, Principal Secretary, Ministry of East African Community. David Kipchumba Kimosop, Managing Director, Kerio Valley Development Authority. Kennedy Nyakundi Nyachiro, Chief Economist and Head of Europe 2 Division, National Treasury. Jackson Njao Kinyanjui, Director, Resource Mobilization Department, National Treasury. Titus Murithi, Inspector General of State Corporations. Paolo Poselli, Director, CMC de Ravenna. CMC de Ravenna Itinerary Joint Venture Italy, CMC de Ravenna Itinerary Joint Venture Kenya. William Kipkemboi Maina, Head of Supply Chain Management, KVDA. Paul Kipkoech Serem, Manager Engineering Services, KVDA. Francis Chepkonga Kipkech, Tender Committee, KVDA. Samuel Kimutai Koskei, Tender Committee, KVDA. David Juma Onyango, Tender Committee, KVDA. Patrick Kipto, Tender Committee, KVDA. Elizabeth Kebenei, Tender Committee, KVDA. Esther Jepchirchir Kiror, Tender Committee, KVDA. Moses Kipchumba, Ad Hoc Technical and Financial Evaluation Committee, 2, KVDA. Engineer Nelson Korir, Ad Hoc Technical and Financial Evaluation Committee, 2, KVDA. Engineer Isaac M. Kiiru, Ad Hoc Technical, Financial and Evaluation Committee, Team 2, KVDA. Engineer Patrick Kipsang, Ad Hoc Technical and Financial Evaluation Committee, Team 2, KVDA. Frederick Towet, Ad Hoc Technical and Financial Evaluation Committee, Team 2, KVDA. Jotham Ruto, Ad Hoc Technical Financial Evaluation Committee, Team 2, KVDA. Charity Mui, Ad Hoc Technical and Financial Evaluation Committee, Team 2, KVDA. Geoffrey Mwangi Wahungu, CEO, National Environment Management Authority. David Walunya Ongare, National Environment Management Authority. Boniface Mamboleo Lengisho, National Environment Management Authority. For the following offenses. 1. Conspiracy to defraud contrary to Section 317 of the Penal Code, Cap 63 Laws of Kenya. Failure to comply with applicable procedures and guidelines relating to procurement contrary to Section 45 2B as read with Section 48 of the Anti-Corruption and Economic Crimes Act No. 3 of 2003. Engaging in a project without prior planning contrary to Section 45 2C as read with Section 48 of Anti-Corruption and Economic Crimes Act No. 3 of 2003. Abuse of office contrary to Section 46 as read with Section 48 of the Anti-Corruption and Economic Crimes Act No. 3 of 2003. Committing an offense of financial misconduct contrary to Section 197(1) or I of the Public Finance Management Act No. 18 of 2012. Fraudulent acquisition of public property contrary to Section 45(1)(a) as read with Section 48 of the Anti-Corruption and Economic Crimes Act 2003. Knowingly giving a misleading document to principal contrary to Section 41(2) as read with Section 48 of Anti-Corruption and Economic Crimes Act No. 3 of 2003 of the Laws of Kenya. Willful neglect to perform official duty contrary to Section 128 as read with Section 36 of the Penal Code. I am cognizant of the principle of innocence until proven guilty, the determination of which can only be made by a court of law. The decision to charge is based on the evidence that is available to the DPP at the time the decision is made, that is today. In view of the international nature of these crimes, we realize that we cannot fight corruption on our own, and as a strategy to fighting economic crimes, the Office of the Director of Public Prosecution has prioritized the tracing of proceeds of crime, benefits and instruments of crime, asset confiscation, and forfeiture. Consequently, these investigations has been phased. To this end, the ODPP has made several international mutual legal assistance requests to the UK and Italy to assist in financial investigations. Once investigations are complete, more charges will be preferred. Being cognizant that corruption always fights back and that there may be elements who may seek to exploit these indictments to instigate social unrest, we have put in place mechanism to monitor any such attempts, which will be countered with whole of government response. Thank you. God bless. Si imetosha. Nimesoma sana.
Can we ask a question?
Okay.
Yes, I have one question based on previous statements. My name is Ken Mujunga of Authoritative. When this issue came out, we were told there was a conflict in the figure that was given at that time. So conclusively, can we say that 19 billion shillings was lost in this? Conclusively, can we say that? And secondly, when that amount was touted also, there was the issue of bank guarantee, so that no money was ever lost. Based on everything that you've told us, can we also say that there was never bank guarantee in this?
I think we'll table the evidence in court, and you'll have all the documentations tomorrow for you to review. It will not be fair for me to comment on those issues. I have said what I've said, and I will give you the statements if you want, and you can go through them. But these are issues that will be argued out in court.
Okay. Yeah. But this is fairly public. When I repeat it, you've mentioned 19 billion. It's fairly public. So I just want a conclusive response. Was it 19? Was it 20? Was it 7? How much was it?
As I said, I don't want to throw a figure here.
Yes.
Because I've been beaten on that. I don't want to throw any figures here. I will put it in court, and we will show properly how we've arrived at the figures that we feel have been lost.
Okay.
Yeah, I think that's only fair, and it's also fair for those who will be arraigned in court. Yes.
My name is Nyambega.
Yes.
There is, from your last statement, you said that the government is working to issue of social interests. Do you have reliable information probably that there are some of the suspects might resort to social unrest so as either to fight the charges?
You see, we are not taking any chances. Yeah, as you all very well know, you're all Kenyans. This issue has really been politicized, so we are not taking any chances whatsoever.
And then, secondly, in the list that you read, I've noted that it does not have. It's not a must for Israel, but it does not have senior officials from the Ministry of Water, including there are several CSs who are told they have been interviewed, including...
Yeah, so if the name is not here, it means we don't have evidence to prosecute them.
Okay.
Yeah, simple, that's what it means. Yeah.
Just been text a supplementary question, if you could allow me.
No problem.
The whole Treasury, the top leadership of Treasury, are on your list.
Yeah.
What does this mean in a country that we know stepping aside and taking responsibility?
They will have to step aside. This is. It's not two ways.
Okay.
These are not governors. They are not. But this is a process that I will write to the head of public service,
Okay.
and they will take.
Has that?
Sorry.
The time you concluded reading the list?
I will do it right away.
Okay.
Yeah.
But you also said that there's a quote. You said that until proven guilty, they are assumed to be innocent until proven.
Yeah, everybody's.
What's the need of them stepping aside?
Because that's the law. That is the law. That if you are charged and you take a plea, then you step aside. Yeah. And stepping aside is not. It doesn't. If you look at the act, you'll see you're paid some allowances and all that. But it's also up to the individuals. In other societies, in other democratic societies, people who face this resign. But unfortunately, that's not what happens in Kenya.
When do we start? When do we expect to start seeing arrests? Or will it be
maybe
matter Friday?
No, maybe ask. You can ask the DCI. He's probably arresting them now. I don't know. So, let me allow you to go and check the arrests.